Legal dictation at the speed of 90 to 100 words per minute. 5 seconds. Start. While refuting the submissions of the appellants, Mr. P.P. Rao, learned senior counsel for the state, on the other hand, submitted that the posts in which the private respondents were regularized were promotional posts to be filled up by promotion from amongst the persons who have rendered 10 years continuous service in the feeder cadre, and the appellants cannot have any claim to be considered for appointment against promotional quota. He submitted that all the 27 advertised posts have been filled up on the basis of the select list prepared by the APSC, and the appellants cannot have any right to claim appointment against the anticipated vacancies which were never advertised, and they have a right to be considered along with other eligible candidates as and when posts are advertised for direct recruitment. He submitted that the law laid down by a constitution bench of this court in state of Karnataka's case supra relied upon by the appellants in support of their case will be of no help and assistance to the appellants, as in the said decision this court has clarified that the regularization, if any already made but not sub judice, need not be reopened on the basis of the judgment. Para. Mr. P.S. Asthana, learned senior counsel appearing on behalf of the private respondents, in addition to the submission of Mr. P.P. Rao, learned senior counsel submitted that the appellants have no right that can be enforced in the present proceedings, particularly in view of the fact that admittedly their names appeared in the select list dated 17/7/2000 below the persons who have been appointed against the 27 vacancies. He submitted that the rules applicable to the present case do not permit inclusion of more number of candidates in the select list in excess of the notified vacancies. He further submitted that the appellants have no locus standi to file the writ petition under Article 226 of the Constitution of India before the High Court, as the private respondents would stand on a completely different footings as compared to the appellants. It was also submitted that the decision to regularize the services of the private respondents was taken by the cabinet in its meeting dated 13/10/2000. It was then contended that the cabinet decision as well as the subsequent notification of the state government have not been challenged in the writ proceedings. The High Court has rightly dismissed the writ petition and the appeals of the appellants. Para. At the outset, it should be noticed that the select list prepared by APSC could be used to fill the notified vacancies and not future vacancies. If the requisition and advertisement was only for 27 posts, the state cannot appoint more than the number of posts advertised, even though APSC had prepared a select list of 64 candidates. The selection list go exhausted when all the 27 posts were filled. Thereafter, the candidates below the 27 appointed candidates have no right to claim appointment to any vacancy in regard to which selection was not held. Thank you.